This meeting of the Senate Judiciary Committee will come to order. Before I turn to the agenda, I want to note for the record that we've moved the Department of Homeland Security oversight hearing that was originally scheduled for today to November 16th. The reason, Secretary Mayorkas tested positive for COVID. The Secretary was willing to appear remotely today, but we discussed it with the Republican side, and at their request, we postponed the hearing until a date when he can appear in person. We have 2 nominees and 1 bipartisan bill ready for a vote. We also have 6 nominees and another bipartisan bill listed for the first time, which will be held over, and they include Lucy Coe to the 9th Circuit, Jane Beckering, Western District of Michigan, Shalina Kumar, Eastern District of Michigan, Armando Bonilla to the Court of Federal Claims, Carolyn Lerner to the Court of Federal Claims, Jonathan Cantor to the DOJ's Antitrust Division, and S998, the Driving for Opportunity Act of 2021. That bill was introduced by Senators Coons and Wicker and has a number of committee co-sponsors, including myself, Senator Grassley, Senator Blumenthal, Tillis, Booker, and Whitehouse. We will also hold over for another week S2428, the Bipartisan False Claims Amendment Act of 2021, at the request of the bill's sponsors, in order to allow committee members additional time to consider a manager's amendment. I look forward to considering these nominations and bills next week. Let me speak to the 2 nominees before us. We'll be voting on Justice Beth Robinson, nominated to the Second Circuit Court of Appeals. An experienced litigator, respected jurist, she's proven that she has an even-handed approach. Justice Robinson's credentials are impeccable: Dartmouth College, the University of Chicago Law School, and clerk for Judge David Sentell on the D.C. Circuit. As a practitioner, she specialized in civil litigation and a concentration on workers' comp. She also maintained a large practice representing LGBTQ clients in civil rights and family law. She was a champion for same-sex couples' freedom to marry and played an instrumental role in a successful lawsuit challenging Vermont's ban on same-sex marriage. In private practice, she dedicated herself to a worthy cause, but since she's been appointed to the bench, she's proven she understands the difference between being an advocate and being a judge. In 10 years on the bench, she's participated in nearly 1,800 decisions. Her colleagues on the Vermont Supreme Court wrote to this committee to emphasize that she has qualities of intellect, judgment, and sound reasoning. A former colleague further stated that she was, quote, always open and equally challenging to opposing arguments from litigants, and, quote, fair, unbiased, and congenial. Unfortunately, some members of the committee suggested that Judge Robinson is somehow biased and hostile to religious liberty. Look at the evidence shows that that clearly is not the case. Consider these facts. In private practice, she represented a Catholic woman who believed she'd been discriminated against because of her faith. As an advocate, Robinson stated, and I quote, if somebody tried to force the Catholic Church to do a gay wedding, I'd represent the church pro bono, end of quote. And as a judge, she held in favor of a municipality that decided to grant federally derived funds to a local church. So these attacks were both unfair and at odds with reality. Justice Robinson enjoys the strong support of her home state senators, Leahy and Sanders, and a unanimous, well-qualified rating from the ABA. Independent-minded, highly qualified, she will be a real addition to the Second Circuit. I look forward to supporting her. We will also vote on Jennifer Sung's nomination to the 9th Circuit, a distinguished juror who brings an underrepresented perspective to the bench. After clerking for Judge Betty Benz Fletcher on the 9th, she served as a prestigious Skadden Fellow. Ms. Sung spent over a decade representing employees and unions and labor disputes. Given her expertise in that area, Oregon Governor Kate Brown appointed her to serve on the Oregon Employment Relations Board, a quasi-judicial agency charged with resolving labor disputes. Unfortunately, some of my colleagues have launched attacks on Ms. Sung, which I would like to address directly. Some have implied that Ms. Sung lacks proper judicial temperament because she signed on to one letter expressing concern over then Justice Kavanaugh's nomination to the Supreme Court. Those of us in public life who have been less than perfect in our choice of words or uttered a belief which we later came to regret should be willing to consider giving someone a break. And Ms. Sung has stated clearly under oath repeatedly, she was asked, I can't tell you how many times about this one letter, that she recognized that those statements made in the letter were overheated. She testified that she has immense respect for the authority of all Supreme Court justices and that she recognizes the importance of faithfully following the law and precedent. Furthermore, as Ms. Sung stated in her responses to questions for record, the best evidence the kind of judge she would be is her extensive track record as a neutral adjudicator on the ERB, and we should consider that record. One of her fellow board members attested to Ms. Sung's, quote, judicial temperament, demeanor that allows all parties to understand their concerns will be heard and fairly evaluated. And listen to what lawyers who represent employees, unions, and employers have said about her in a letter that they submitted to this committee. She has, quote, impressive intelligence, diligent preparation, respectful courtroom demeanor, and judicial impartiality. It appears that some of my colleagues on the other side of the aisle have forgotten when some of their nominees could not pass the one-letter test and were approved by them. I think we should all take to heart that each one of us in public life has at least the possibility of saying something that we later regret. I also want to address claims that she doesn't have enough experience, despite the fact she practiced law for over a decade and served in a quasi-judicial function for almost 5 years. If that sounds familiar, it's because of what circuit court judges do. It also appears that some of my colleagues want to apply a litmus test, and I would remind them that nominees like Trump D.C. Circuit nominee Naomi Rao had no experience practicing even before a court or agency. What's more, Ms. Rao, when asked on the committee questionnaire to list her 10 most important litigated matters, she could only come up with 3. Yes, yet all the committee Republicans supported her. Another Trump nominee, Justin Walker, had never served as sole or lead counsel in any trial, yet all the Republicans supported his nomination to a district court and again to the D.C. Circuit. Let me say a word about demand justice. It's been brought up many times by the other side of the aisle. I want to reiterate again the judicial selection process is being driven by President Biden and the members of the Senate, no one else. To my knowledge, demand justice has no role in choosing judicial nominees. Do you recall the role of the Federalist Society under the previous president? Then candidate Trump stated in a June 2016 radio interview, we're going to have great judges, conservatives, all picked by the Federalist Society. And then White House counsel Don McGahn boasted in 2017 about the prominence of that group in the selection of judges. It's ironic that those who supported the Federalist Society in selecting judges are now shocked, genuinely shocked, at the much lesser role of demand justice. Ms. Sung has the strong support of Senators Merkley and Wyden, well-qualified rating from the ABA. She'll bring much-needed demographic and professional diversity. In addition, we have one bipartisan bill. The bill is S-2429, the Administrative False Claims Act of 2021, introduced by Ranking Member Grassley and myself, co-sponsored by Senators Hassan, Lankford, Portman. I'll speak more about this bill when we turn to it, and with that, I turn to my Ranking Member, Senator Grassley.
Okay. Because there's nominees and a bill on the agenda for the first time, our side would like them to be held over for the normal week under the committee rules. I'm pleased that S-998, Driving for Opportunity Act, is on the committee's markup agenda. I'm a co-sponsor of this bipartisan bill and look forward to its consideration and advancement next week. Before we discuss the judicial nominees, I want to talk about the draft report published by the White House Commission on Packing the Supreme Court and other so-called reforms. It's good to see that the Commission's draft acknowledges the historic risks that come with this attack on the judicial independence. Technically, the Commission didn't take a position on packing the court. The report says, quote, the commissioners are divided on whether court expansion would be wise, end of quote. But the report also acknowledged many Americans would see court packing as, in the words of the report, as partisan maneuver. Of course, that's very obvious. As President Biden noted in 2019, packing the Supreme Court would mean it would, quote, lose any credibility the court has at all, end of quote. the dark money groups and their allies in the Senate pushing for so-called reform. No, it's a radical proposal. It will damage the credibility and standing of the Supreme Court. So I'm glad to see that people recognize the dangerous game that these leftist activists are playing in attacking the court. I'm interested to see if the Commission's final report reflects these simple truths. I plan to vote no on both of the judicial nominees today. I have a statement that I'll place in the record explaining my reason on those votes. I introduced the False Claims Act of 2021 over 3 months ago. Since that time, my staff has had meetings with stakeholders as well as reach out and talk with every member on the Republican side. We did more than just talk, we listened. The main concern expressed by most of my colleagues was the potential of overreach and unintended consequences. To address my concerns, colleagues' concerns, we developed a manager's amendment to further refine and clarify the intent of the bill. And now, in an effort to be transparent as possible, Chair Durbin and I agreed to postpone this vote in order to give ample time for the public and everyone on the committee to review the language. I'd like to thank all of our co-sponsors and my colleagues for working with me to finalize that. Mr. Chairman, I want to take just a little bit of time to expand on what I just said about the bill we held over. And it's for all of my colleagues that maybe have come to the Senate in the last 20 years, don't know about the benefits of the False Claims Act. It's brought in $67 billion of fraudulently taken money from the taxpayers. This whole approach to Ketam started in the Civil War, Lincoln, and it worked pretty good until 1942 when it was gutted by the Congress of the United States because of the war efforts. Everybody thought that if you were going to sue these defense contractors, we might not win World War II. So it was that way for the next 50 years. And then in 1986, we finally come forward with the Ketam provisions that makes this law possible to bring back $67 billion of fraudulently taken money. Now understand that to get this bill passed in the first place, we were fighting the defense contractors for a whole year. Get the bill out of committee, I think with a fairly wide margin. By the way, I need to compliment Senator Leahy because over the last 20 years, he and I have sponsored bills to override court decisions that weaken the original intent of the bill. So I thank Senator Leahy for doing that. But remember that it was originally the defense contractors. They fought this idea over and over and over again. And when I finally got the bill out of committee, then they go to this senator to put a hold on. You go to that senator to explain what the bill's supposed to accomplish, and they said, it sounds like a good piece of legislation. And then they get another person to put a hold on the bill, and another person, and another person. Finally, they went to Jesse Helms, because with Jesse Helms, they'd be able to kill this bill forever. I talked to Jesse Helms about it. Can you lift your hold? He said, I read the bill. It makes common sense to me. We got the bill passed, and it was signed by the President of the United States. So what are we still talking about today? You get court decisions that gut the bill because they interpret something different than what we intended, or the Department of Justice is doing something. So Leahy and I come along, and we try to correct what the courts are doing a disjustice to the original purpose of the False Claims Act. And that original purpose has ended up with $67 billion of fraudulently taken money. So when we're trying to correct some misinterpretation by the court, it should be a non-controversial thing based on the fact that this legislation works. So I hope next week, when we're working on this bill, you'll think about the history of it and what it is. Now, the defense contractors have given up after 20 years. Various pieces of amendments they tried to get adopted on the floor of the Senate. They couldn't get it adopted. Now there's other interests that think, boy, we don't want to put up with this False Claims Act, so they're giving Leahy and me problems on getting these corrections passed. I hope you think about that for the next 7 days.
I will. I hope everyone will join me in thinking about it, and we know you're
And thinking hard about it.
thinking hard.
Bravo, Senator Grassley.
Well,
I agree with you, Charlie.
thank you, sir.
I knew as soon as you said something nice about Senator Leahy, he would agree with you. And before we go to the legislation before us today, we're going to consider the nominations, and the first is Beth Robinson. Does anyone wish to speak to that nomination?
If I could just say a moment, I'll put my whole statement in the record, Mr. Chairman, but I thank you for doing this. I would note that she has probably this, in fact, most of us wish we could have this kind of support in our state. She has the support of our Republican governor, the Trump-appointed U.S. attorney, got a unanimous vote in our legislature. Every Democrat, every Republican voted for her. She has probably the broadest type of support I've ever seen of anybody, and I've had some wonderful nominees from Vermont come here. She has the broadest support I've ever seen. I like her even though she went to Chicago Law School and not to Georgetown like you and I did, Mr. Chairman, but I will put my full statement on the record, but I definitely look forward to having her on the Court of Appeals.
Anyone else seek recognition?
Mr. Chairman.
Senator Lee, then Senator Hirono.
Thank you, Mr. Chairman. I've got a couple of concerns. This nominee was the attorney for the plaintiff in a case called Paquette versus Regal Art Press. In that case, she argued that a Catholic printer, a devout Catholic who owned a printing shop, could not lawfully refuse to print a pamphlet taking pro-abortion stances for a pro-abortion clinic. Now, she called in that case, she called the printer's refusal invidious and pernicious and compared it to racial discrimination. This is concerning to me on multiple levels. Multiple protections within the First Amendment seem to be undermined by her reasoning in that case. And the fact that she was willing to argue in a brief that someone has a duty, somehow has a legal obligation as a printer to print something in violation of that person's freedom of speech, freedom of press, and religious freedom is concerning to me. Now, look, I get she was an attorney. She had a client. It's pretty strong medicine, though. I mean, it's a pretty bold argument that undermines the First Amendment. There's another case, an opinion she was involved in the state of Vermont versus Kozlowski. When she dissented from a decision by the Vermont Supreme Court affirming the conviction of a defendant. This defendant had threatened his girlfriend's daughter with a box cutter, holding the box cutter up to her and saying that he would kill her in her sleep. She was convicted on that basis in the trial court. The Vermont Supreme Court upheld that conviction on appeal. But she dissented in that case, stating her assessment that she believed that the conviction was erroneous. Erroneous because of the unique shape of the box cutter and the contention that it could not have harmed her. It was a box cutter. Box cutters can do harm, especially when held up to a small child. A small child doesn't know necessarily whether that box cutter can, in fact, cause harm. She said, quote, "The threat in this case is akin to the threat to use a pillow to swat someone's backside." Mr. Chairman, I find that reasoning and that conclusion difficult to accept. It's almost unfathomable. One could compare holding a box cutter up to someone, a small child, threaten to kill that child in that child's sleep, to saying that that's akin to a threat to swat someone on the backside with a pillow. These things give me grave concerns about this nominee. Thank you.
Thank you, Senator Lee. Senator Rono?
Mr. Chairman, I understand that we're on Ms. Robinson, so my remarks are relating to Ms. Sung. I can wait until we get to her
Okay,
nomination.
fine. Anyone else seek recognition on the Robinson nomination? Senator Hawley.
Thank you, Mr. Chairman. I just want to add my agreement with Senator Lee's remarks about Ms. Robinson. And in particular, I want to come back to the Paquette case. I asked Ms. Robinson, or Ms. Paquette rather, or Ms. Robinson, why in representing Ms. Paquette, she thought it was acceptable to try and use the coercive power of the state to force Catholics, devout Catholics, to print cards, in this case, pro-abortion cards, pro-abortion messages that directly contradicted their religious faith. I was struck by her answer because she gave the same answer to Senator Cruz. She said, actually, this was a doctrinal dispute, that her clients were also Catholics, and they felt that the printers in question, the Catholic printers in question, were misinterpreting their church's doctrine, and so for that reason, since it was a doctrinal dispute, it was okay to use the power of the state to force these printers to print the message. That doesn't make it better, that makes it worse. I mean, this is essentially saying that the state is fine and should intervene in doctrinal disputes within a church and adjudicate what the proper outcome is, the proper doctrine, and then force the parties, the adherents of the faith, to follow the court's interpretation. I mean, it's really, really disturbing. Can I just say, by the way, for the record, that's a gross misstatement of what the Supreme Court has repeatedly said is the court's role in any kind of religious dispute. The court never takes a position on intra-religious disputes. And of course, we've until recently had a long tradition of not forcing adherents of a faith to violate their own faith in order to deliver a particular message. And I would finally just add that I agree with Senator Lee that the description of the Catholic printers in this case, their behavior, their adherence to their religious beliefs as being invidious, as being pernicious, and as being akin to racial discrimination is really a slur on those good folks and a slur on religious believers who are just following the teachings of their church, as they were in this case, in choosing not to make a statement. This is a speech act, in choosing not to endorse a particular viewpoint and in choosing to make a speech act that's consistent with their own faith. So for those reasons, including the others offered by Senator Lee, I'm going to oppose her nomination.
If no one else seeks recognition,
I could just make one slight comment. I know a lot about Catholic printers in Vermont. I think of the Leahy Press, owned by my mother and father, devout Catholics, as am I, and I strongly support her. Thank you, Mr. Chairman.
on favorably reporting the nomination of Beth Robinson to be U.S. Circuit Judge for the Second Circuit, the clerk will call the roll.
Mr. Leahy.
Aye.
Mr. Feinstein.
Pass.
Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Mr. Rono.
Aye.
Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Pass. Pass.
Mr. Corning.
Mr. Chairman, this is on the Robinson nomination.
yes.
I vote no.
Mr. Lee. Mr. Cruz.
No by proxy.
Mr. Sachs.
No.
Mr. Hawley. No. Mr. Cotton.
No by proxy.
Mr. Kennedy. No. Mr. Tillis.
Pass.
Mrs. Blackburn. No. Mr. Chair.
Aye.
Chairman, the votes are 10 yeas, 9 nays, and 3 passes.
The nomination will be favorably reported to the floor. And now we consider the nomination of Jennifer Sung to the Ninth Circuit. Is there anyone who wishes to be recognized on that nomination? Senator Cornyn.
Mr. Chairman. Mr. Chairman, Senator Feinstein has been a good friend of all of ours for many years and has served this institution with great distinction. Yesterday, she let me know that she was called back to California on a family emergency. She asked that I vote present today on one nomination, the Sung nomination, so that she could be with her family. And I intend to do that on the Ninth Circuit nominee, Ms. Sung. In doing this, I follow the great example of Senator Coons, as I recall, when he paired with Johnny Isakson when Senator Isakson was ill. I recall during a particularly contentious time on the Senate floor, Senator Murkowski did the same thing with a Democratic colleague. This used to be fairly routine in the Senate, and I think is the type of civility that we would do well to return to. Just to be clear, my vote of present today would have the same effect as if Senator Feinstein were here. If I did not vote present, then it would just delay this for a week before she could return. To be clear, I have serious concerns about Ms. Sung, but out of a spirit of comedy and support for our friend, Senator Feinstein, I'll vote present at this time.
And the chair would like to take a moment to commend you for that civility and hope that it is contagious. It would be a great thing for this institution if we return to that standard. Thank you, Senator Cornyn.
And I think, Mr. Chairman, Senator Cornyn will recall, I believe he was whip at the time in a very close vote coming up in the Senator from Alabama. Senator Shelby was ill, and I paired with him on the floor on that close vote so that he would not have to try to come to the floor when he was not feeling well at all.
Thank you for reminding me, Senator Leahy. I applaud you for your example.
Does anyone else seek recognition?
Mr. President, I just want to mark
Senator
the
Booker.
moment and how much that really means to me to see Senator Cornyn really show such a grace towards his colleagues. It's really what gives me a little spark of hope in this place, that we are still a place that recognizes that virtue really is seen in kindness. So thank you very much, Senator.
Senator Padilla, and then Senator Lee.
Thank you, Mr. Chair. Too, just want to lend my voice in thanks and acknowledgement to Senator Cornyn. Senator Cornyn, we've done some good work this week, but I appreciate, on behalf of Senator Feinstein and my office and the nominee and all the hardworking people of the Ninth Circuit, I just want to say thank you for letting this advance without delay.
Senator Lee.
Thank you, Mr. Chairman. I've got concerns with this nominee. Ms. Sung was someone who, when she came through this committee, I asked a series of questions to her about a letter that she had signed a couple of years ago, at about the time Justice Kavanaugh was nominated to the Supreme Court. It was an open group letter signed by Yale law students and Yale alumni. The letter was defamatory. I don't really know of a better, more polite way of describing it, but it was an act of defamation. The letter stated that Justice Kavanaugh, then Judge Kavanaugh, was, quote, morally and intellectually bankrupt. It also asserted that his confirmation would lead to people dying. Now, nowhere in the letter was there an attempt to draw a causal connection between the confirmation of Justice Kavanaugh and people dying, but it made this assertion nonetheless. So, I thought she might have an explanation for the letter when I asked her about it. I thought she might either have had regrets or want to clarify something about the letter, so I asked her about it when she came before the committee. She never apologized, never retracted any aspect of the letter, but I asked her, you know, are these words not pretty inflammatory? If you call someone morally and intellectually bankrupt, and if you make the assertion that the confirmation of that person to a judicial post will cause people to die, shouldn't there be some explanation of what that means? So I think if you're ready to stand by it, I'd like to know on what basis you stand by it and on what basis you can defend it. If you don't stand by the letter, if you can't defend it, then I'd like to know that too. She did neither. Despite repeated opportunities, I tried to throw her a number of opportunities to do one or the other. I'm not trying to catch her, but I wanted to resolve this concern about her judgment and about her commitment to the truth. She refused to do so, and to my amazement, to my astonishment, she instead dismissed it as quote-unquote overheated rhetoric, and then claimed that she didn't know that the letter was going to be made public. Now, I don't know what relevance that mistaken belief had. I don't know why that should make any difference to a person's willingness to sign her name to a letter defaming another person in the first instance, and then refusing to back away from it, apologize for it, or back it up in the next instance. I don't know what relevance that has to simply say, well, I didn't know it was going to be made public. Instead, she claimed that it was, to her understanding, going to go only to the leadership of the Yale Law School, even though it had hundreds of signatures, and it contained the words open and letter together on the letter. The indication of an open letter is that it is precisely that, written right there on the top. But regardless of whether she knew the letter was going to be published, which again I think is utterly beside the point, her signing that letter showed, I think, an exceptional lack of judgment, as does her unwillingness to apologize for the statement, or alternatively, her inability to back up and defend the legitimacy of the statement. In addition to the judgment, I also questioned her about it for the simple reason that I wondered, and still wonder today, whether someone who refers to someone in that position as morally and intellectually bankrupt and accuses that person of being someone who is going to cause other people to die by virtue of his being on the Supreme Court of the United States, it does call into question, in my mind, her ability, her willingness, her inclination to respect Supreme Court opinions authored by, or perhaps even joined by, Justice Kavanaugh. Look, I understand sometimes people say things in the heat of the moment. Sometimes people even sign their name to letters. And maybe it might even make it easier for them if, in this instance, maybe it made it easier for her to sign it if she mistakenly believed that it wasn't going to be made public. It still doesn't answer the question of why that's acceptable. I don't think it is. I've got grave concerns with her, and I'll be voting against her. Thank you, Mr. Chairman.
Thank you, Senator Lee. Before recognizing Senator Hirono, let me note, as Senator Cornyn has said, Senator Feinstein could not attend today's markup because of a serious family situation. She has, however, asked me to submit a statement for the record expressing her support for both of the nominees receiving a vote, and without objection, I'll do that. I'll submit the statement to the record and recognize Senator Hirono.
Thank you, Mr. Chairman. I, too, would like to thank Senator Cornyn for honoring Senator Feinstein's request. Thank you. Mr. Chairman, I offer my strong support for Jennifer Sung to be on the Ninth Circuit. And the subject of the letter, the single letter that she signed, keeps coming up. I think that she explained herself very well, and at the same time, I recall that there were over 1,000 law professors and deans of law schools who signed a letter to this committee that Judge Kavanaugh did not have the requisite judicial temperament to be on the Supreme Court. I also recall many Trump nominees who took various positions that raised plenty of questions about their competence, judgment, objectivity, including one who thought dwarf tossing was okay. It's very important for people with diverse backgrounds, with a reputation for fairness and objectivity, to be on our courts. That is Jennifer Sung. She will bring some greatly needed personal and professional diversity to the federal bench. Before attending law school, Ms. Sung worked for labor unions and then went on to represent employees for more than a decade. These employees were often from low-income and underserved or marginalized communities. Moreover, Ms. Sung grew up with the unique perspective of immigrant parents. She has lived and understands the need for our laws and government to serve all of its people. If confirmed, Ms. Sung will be the first Asian American from Oregon on the Ninth Circuit and only the third Asian and Pacific Islander woman to serve on any federal circuit bench. Regarding her reputation for fairness and objectivity, I think it's instructive to look at the opinions and views of the people she has worked with in her professional life. As a member of the Oregon Employment Relations Board, Ms. Sung worked in a quasi-judicial capacity, working with her fellow board members to hear, consider, and rule on labor and employment cases. The chair of the board, Adam Reinhardt, supports Ms. Sung's nomination, saying, quote, Ms. Sung has proven herself to be a fair-minded, hardworking, and dedicated public servant with the utmost integrity and intellect. She has a judicial temperament and demeanor that allows all parties to understand that their concerns will be heard and fairly evaluated, end quote. Citing the importance of neutrality and even-handedness to the agency, he further states, quote, Ms. Sung embodies those qualities and is a consensus builder and a valued colleague, end quote. Her fellow board member, Lisa Omscheid, writes, quote, despite the fact that Member Sung and I have spent our professional careers on the opposite sides of the labor management divide, I have consistently found Member Sung to be receptive to and understanding how a particular case will affect public employers and the public managers who administer them. I can unreservedly say that Member Sung is hardworking, fair, always prepared, and always courteous to the litigants and counsel who appear before her. She approaches the work of the board and the overall mission of ERB with the utmost integrity and intellect. End quote. Moreover, attorneys who represent management in employment and labor matters, who have served as opposing counsel to Ms. Sung and raised matters to the board on which she sits, praise Ms. Sung and say, quote, a more outstanding person could not have been nominated for this position, end quote. So in their letter of support, they write, quote, in our dealings with Ms. Sung, her objectivity, fairness, and professional demeanor have been exceptional. While we do not always agree with Ms. Sung's positions on decisions, those decisions have always been well-reasoned. Matters related to employment and labor are prone to emotionally charged interactions between opposing sides. Even in such an environment, Ms. Sung has always maintained a very professional approach, end quote. These are the statements of people who have worked and interacted with Ms. Sung for years, including colleagues, as I mentioned, who have represented the opposing side or viewpoint. Ms. Sung embodies all of the qualities we hope for a federal judge: objectivity, fairness, hard work. And I think it's a major plus that she brings to the court her very unique life experiences. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Coons seeks recognition, and then we'll call the roll.
Thank you. If there's no other senator seeking recognition, I'll be brief. My impression was that Ms. Sung did in fact respond to raised concerns and questions about this letter. There are obviously hotly contested views about nominees and about the nomination process, and in response to persistent questioning on this topic, She sincerely and repeatedly affirmed her respect for Justice Kavanaugh, his authority in the court. And I also just wanted to thank my colleague from Texas. My gesture to our shared dear friend Johnny Isaacson was in no small part occasioned by another senator on the day that my father died, coming to me on the floor and offering to pair. So these gestures are much more than just gestures. They're part of the connective tissue that allows us to continue to respect each other and work together even in a divided time. So thank you very much, Senator.
Thanks, Senator Coons. On favorably reporting the nomination of Jennifer Sung to be U.S. Circuit Judge for the Ninth Circuit, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein?
Pass.
Mr. Whitehouse? Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Mr. Rono? Mr. Booker? Mr. Padilla? Mr. Ossoff? Mr. Grassley?
No.
Mr. Graham?
No by proxy.
Mr. Cornyn?
Present.
Mr. Lee?
No.
Mr. Cruz?
No by proxy.
Mr. Sass? No. Mr. Hawley? No. Mr. Cotton?
No by proxy.
Mr. Kennedy?
No.
Mr. Tillis?
No by proxy.
Mrs. Blackburn?
No by proxy.
Chair Durbin?
Aye.
Chair Durbin, the votes are 10 yeas, 10 nays, 1 present, and 1 pass.
The committee has recorded a tie vote on Ms. Sung's nomination to be U.S. Circuit Judge for the Ninth Circuit pursuant to Section 3, subsection 1A of Senate Resolution 27 of the 117th Congress. I'll transmit to the Secretary of the Senate a notice of this tie vote. Under Section 3, subsection 1B of that resolution, either the majority or minority leader may then make a motion to discharge the nomination. We now have before us the Bill 2429. Does anyone else seek recognition to speak to that bill? Senator Grassley has made one statement, but I want to give you a chance if you want to speak again.
First of all, after I get done speaking about the other false claims bill, I realized I was yelling at everybody. I'm not mad at anybody. I don't even know who's involved in this manager's amendment to satisfy everybody, but I want to apologize if I offended anyone.
No apology necessary.
Okay, thank you.
That has to be listed as a co-sponsor.
You may get angry over that, but Senator Leahy allowed that.
Now, this bill that's before us now, the Administrative False Claims Act, will update and rebrand the Program Fraud Civil Remedies Act, also known as the Many False Claims Act. The law allows Congress, government agencies to combat lower dollar fraud perpetrated against the government through administrative process. The Administrative False Claims Act updates the law in several important ways. It raises the current statutory ceiling for lower dollar fraud from $150,000 to $1 million. It allows federal agencies to regain the funds that they expended investigating and prosecuting fraud. It allows the Attorney General to delegate some of his approval authority to lower-level DOJ officials in order to timely prosecute these instances of fraud. It allows agencies to utilize additional courts to hear these cases. In short, this act better empowers the federal government to combat the more frequent instances of just low-level fraud by deputizing its agencies to take them on, freeing up DOJ to take on the larger cases. I have letters of support that I'd like to place on the record.
Without objection, anyone else seek recognition? Senator Blumenthal.
To be added as a co-sponsor.
Without objection. Any further comments on the bill? Unless there's a request for a record vote, on favorably reporting S-2429, all those in favor say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. The Judiciary Committee stands adjourned.